There were plane loads of people. There were no procedures in place to notify people. Nazis got better treatment under the Alien Enemy Act than has happened here.
An Obama-appointed federal appeals court judge that appears to be echoing left-wing talking points during a hearing about the Trump administration's deportation of alleged Venezuelan gang members. Let's bring in criminal defense attorney and federal litigator Vic Bajaj, along with Eisner-Gorn criminal defense attorney Robert Hill. Gentlemen, great to have you both on here. The Nazis got better treatment. Vic, what do you think of the comment?
You know, when you're using the Nazis as an example for anything, a wise man once told me you need to rethink that strategy. I wonder if due process for Nazis is exactly the standard that we need to move towards. And this is why. Under the Alien Enemies Act, due process is essentially, like it or not, thrown out the window, and all that discretion is given to one person. You know who that person is, Trace? It's the President of the United States of America, who solely has the discretion to declare an invasion or an enemy incursion. No one else, and that's in the statute. So for this judge to say, hey, we need to have due process, that ignores what the Constitution gives the power to the President of the United States, and it ignores the law. What it does is shows a partiality and the need to reach the result.
Meantime, you heard what the Obama-appointed judge said about the Nazis. Here's a Trump-appointed judge. His name is Justin Walker, and he said the following. Watch.
Can you just tell me what's an example of a district court enjoining a national security operation with foreign relations implications? I think we could at least agree on that.
Fair question, Robert, right?
It's a fair question. I think they may ultimately not like the answer that they get from the Supreme Court, particularly in light of the breaking news you had earlier this hour about the invocation of the state secret privilege. Justice Gorsuch, in particular, has been very skeptical of the invocation of this type of national security-based secret rationale. He wrote in 2022 about a case involving foreign black sites that he was troubled by it, and he brought it up again just a few months ago in the TikTok ban case, where the government had relied in the lower court partially on secret evidence that they refused to share with opposing counsel. He was very troubled by that, and he only ended up signing on to the opinion because they didn't base it at all on that secret evidence. So while that may work for now to just say, get on the plane now, have your process later, and you don't get a hearing, and we won't tell you why because it's a secret, I think they may ultimately not like the result.
But that's where they wanted to go.
That's where they
wanted to go to the Supreme Court. Trump now asking Supreme Court to block reinstatement of federal workers. He said the following, quoting here, Acting Solicitor General Sarah M. Harris wrote in her application the preliminary injunction had allowed third parties to hijack the employment relations between the federal government and its workforce. Another one, right to the top, Vic, is what they'd like.
Thank goodness we have a Supreme Court now that really looks at the text of the Constitution. What this means for our viewers and listeners is it's an originalist court. What does the Constitution say, and what does it mean? Forget about the interpretations, the living, breathing Constitution. What does the text say? The text says, in this instant, President Donald Trump has executive power to make these very decisions. End of story. And when it gets to the Supreme Court, an originalist interpretive court, that's the result that will end up being on our desks.
Meantime, you've got two lawsuits being filed over the dismantling of the Department of Education, one by the American Federation of Teachers, filed, by the way, in Massachusetts, not surprising. The other one by the NAACP, filed in Maryland. They do not want the DOE dismantled. It's happening as we speak. Do they have a chance?
They have a chance. The Department of Education is a congressional creation. It was created in 1979 by a statute, and it can only be unmade completely by Congress. Right. And I think the administration knows this. If you look at their statements in response to the lawsuit, they're walking back the original language, which was more fun, to say we're dismantling it, we're destroying it, we're ending the Department of Education. Now they're saying, whoa, really, we're exercising our limited authority to not do more than we have to do, but we're going to work with Congress. This is another instance where, you know, it's fun to talk big, but then when you actually get into court, we need to start looking at what the law.
They want to take 50+% of it. They're saying we're going to take 50+% and we're going to throw it out the window and see what happens after that. Robert, Vic, thank you both.